You're live. Good morning. It is March 20th. We're in Senate Judiciary. We are getting a walkthrough on page 540, and we have Ledge Counsel here with us, and the floor is yours.
Thank you. For the record, Hillary Cheddar Ames, the Office of Legislative Counsel. We have H540. This is a bill that adopts the recommendations from the final report of the Post-Adjudication Reparative Program Working Group. So context for what that working group was, in 2024, the legislature passed Act 180, and that act created a free charge program. But there were also existing diversion and restorative justice programs that were post-adjudication. There were a variety of statutes. So Act 180 also created a working group to review and make recommendations about post-adjudication diversion and restorative justice. And one of the ideas was to make sure that the references to post-adjudication restorative justice approaches in statute were clear, consistent, and that there were uniform operations and procedures statewide. So the working group had a number of members, including the DOC Commissioner Designee, Superior Court Chief Judge, and 5 representatives from community justice community providers across the state. They had to submit an interim and final report. They did that, and that final report recommended the statutory changes that you see in the bill. So moving to the language, Section 1 amends 13 VSA 7030. That's a section that sets forth the factors a court must consider in deciding what sentence to order. The two changes are made on page 2. This is lines 2 through 11. The first on line 2. So one of the sentence options is referral to a community reparative program. As you'll see shortly, since the bill changes creates a uniform program in another section, this change from board to program is meant to be with that change.
Sorry, I might be lost. Are you, what page and line are you on?
Page 2, line 2. Although if I'm looking right there, it looks like I have a different header on my printed version. So I might steal this to make sure that I'm giving you the right page numbers. Great. So on your version, it is page 1, line 15. And this is one of the sentence options is referral to a community reparative program. And this changes for the program consistent with the other changes made in the bill. The second change removes several lines of language, but it's not a substantive change. I'll point out this language just gets moved to what is a new kind of single source section for all the information about community reparative program. The rest of section 7030 really just has short lists identifying the sentencing options. So the fact that this has several sentences explaining what that option is kind of an outlier. So this change makes section 7030 more consistent, and it provides that more detailed information about referral to a community reparative program in a later section. So any questions about that before we move forward? Perfect. In section 2, this describes what the chapter establishes, program for restorative justice post-adjudication. The first change is on for you, page 2, line 8. And this is a change to clarify what is current practice and law, that participation in a restorative justice program can be either a sentence or a condition of a sentence of probation. More on that shortly, but that change on page 2, line 8, makes very clear that that's the case. It is made clear several other times, as you will soon see. The other change, a substantive one, this is page 2, lines 9 through 10. Under current law, referral to a restorative justice program is available for civil contempt of a child support order. So if someone does not pay a child support order, they're found in contempt. Current law would allow them to be referred to a restorative justice program. The working group report recommends removing that, and the report gave 2 reasons. The working group members said they had never seen it used that way, and they also did not think it was necessarily an appropriate use of the restorative justice program. So I believe there were other witnesses who can explain that further, but that was the kind of high level reason given in the report. So moving forward to section 3, this is the real meat of the bill. Section 3 adds a new statutory section, section 913, with all of the details about referral to a restorative justice program, to the restorative justice program. So as a heads up, subsections A and B are not new. That is, that's been carried forward from the language on pages 1 and 2 that was removed from section 7030. So not a change to current law, this is just putting it in place. Now this section is kind of a one-stop shop for everything you should know about referral to the restorative justice program. So subsection A describes in current law what cases are eligible for referral to the restorative justice program. No substantive changes there. Subsection B specifies something I mentioned earlier, that referral to the restorative justice program can happen even if the court does not place the offender on probation. This section also describes what happens if referral to the restorative justice program is not a condition of probation. If the restorative justice board, cooperative board program does not accept the case, or if the person does not complete the program to the satisfaction of the reparative board in a timely manner, then they go back to the court and the court will consider further sentences. Subsection C, again, clarifies that referral to the restorative justice program can be a condition of probation. So we have that a couple times in statute now, just to be very clear that referral to the restorative justice program can be a condition of probation, but it can also be a sentence separate from condition of probation. And in that case, if there isn't, if the board doesn't accept it, or if a person doesn't satisfactorily complete it, then they come back to court for further sentencing. Subsection D, so this is page 3, lines 7 through 17. This is new. These factors are new. They're not somewhere else in current statute. They're based on the working group members' experience, but they provide the kinds of factors that a court should consider, must consider in determining whether to order that an offender participate in the restorative justice program. So these examples 1 through 6 of factors are not exhaustive. The statute or the bill says the court shall consider any relevant factors, including, so the court could consider relevant factors other than the ones listed here, but those factors might include these 6, and these 6 give an idea of what relevant factors may be. Moving forward, subsections E and F are both new. These are both getting at making sure that there is consistency and uniformity across the state. The working group report talked about the need in these 2 places to avoid geographic disparities in the use of the reparative program as a sentencing option. So subsection E calls for standardized forms to be used across the state. The court administrator would be, must create those. And subsection F calls for standard procedural rules to be used across the state. And that allows the Supreme Court to adopt procedural rules to support this. Again, the bill can't order the Supreme Court to direct them, but this suggests that that be the case.
Can't they already do that with adopting procedural rules?
I think their existing authority would certainly cover that. I think the idea behind including it in statute would be to suggest that particular rules, procedural rules for referral to restorative justice programs would be useful. Other witnesses might be able to speak more directly to that. Section 4, this is page 4, lines 3 through 4. Are the effective date, and the effective date is set for July 1st, 2026.
Thank you. Any questions? Sorry, Ross.
Yeah, just a quick one. So Hillary, so just for clarity purposes for myself. So when we refer to the community reparative program, this is the restorative justice program, the members of okay.
Yes, so my understanding is that across both Title 13 and Title 28, there are a variety of terms used to refer to different restorative justice approaches. This, I think, tries to make sure that within Title 13, there are some consistent terms used. I think there might also be some other places in statute where these terms will need to be updated and made consistent. But I think that wasn't necessarily within the scope of the board.
Thank you. Great.
Morning. I will say that is a tough act to follow with that presentation because having been the chair of the committee and worked on the report, I think that Hillary's explanation was exceptional. She captured much of Elm zoning, Chief Superior Judge. She correctly explained everything. What might be helpful to understand for the committee is that the working group met. The working group, as Hillary indicated, was designed to have myself together with individuals from community justice centers. And there was statutory requirements to consult with stakeholders, and that was done. We reached out to all the entities under the act that we were supposed to. We heard back, we had input from state's attorneys, the Attorney General's Office, Center for Crime Victim Services, and also not just the representatives of the CJCs, but they reached out to their colleagues in every county, I understand. So we heard from all the CJCs. We reviewed statutes, we reviewed input, we talked about experience. And so the bill that you have before you really is an effort to make things work better and be, if you will, one-stop shopping. And the restructure, moving some of the language from Title 13 to Title 28 was designed to have clarity. So when people want to see how does the reparative program work, here it is. And there's the reference in Title 13 under a sentencing alternative, and it takes you to Title 28, and you can go through what's there. No substantive changes in terms of what cases are able to be sent. We didn't get into that recommendation. Importantly, one of the questions was asked, well, right now, what's the criteria? What are the factors? And we don't have any. And so that's why on page 3, the working group concluded that there should be relevant factors that were identified for judges and the parties to consider. And we also thought that it would be a good idea to have standardized forms across the state. And in answer to your question, Senator Hashim, I do think much like with rules for probation violations and sentencing under the rules of criminal procedure, that the court can adopt rules. This just makes it clear that everyone's on notice. The court may adopt rules. But one of the points that the CJC's representatives highlighted was some forms. That's something that if you go to County A and County B, we're all on the same page as to what things look like. That's because the idea and the factors also, they help to reduce any potential geographic disparities.
That's great. So I guess my other question for you, Judge, is beyond adding in these factors that the court shall consider, are there any other substantive changes in terms of what types of defendants and what types of cases can go through the programs?
No.
Okay.
That was carried forward. It was intentional to not make those changes.
Yeah. Okay. Great. Because I was initially confused for a moment when I saw the differentiation between the probation conditions and than adding a sentence as a possibility, because it's my understanding it could already be a sentence and not necessarily probation.
Correct. Under current Vermont law, an individual who, let's say you have somebody for unlawful mischief, and the judge thinks they should go to the reparative program. The court can, if the individual pleads guilty, the court can say, I am sentencing you to the reparative program. And they go to the reparative program. If they complete it, their sentence is complete. The court could also sentence the individual to a term of probation and include the reparative program, which once they do the reparative program, they're still on probation. And so the structure of the statute was to make it clear that we do have that first option, because that minimizes that DOC, for instance, would have people being put on probation who otherwise may not need it just to complete the reparative board. And it makes it clear that that can occur.
So I guess in summary, this bill, one, it cleans up the statutes and kind of reorganizes it a bit to make it a bit more clear. It adds the relevant factors and makes it more clear for when sentencing comes around that it can either be a sentence or it can be a part of a probation condition. Is that kind of the summary?
Yes.
Okay. Am I missing anything else?
I would only note that the budget impact is zero. In other words, it doesn't cost anything to do this. And as I testified, I think in House Corrections, this is a bill that everyone on the committee, the group was behind, because we think it has significant improvements from where we are now. And as you point out, it brings clarity. And that type of clarity, that type of predictability benefits all who come into the system.
Great. Thank you. Actually, I guess one more question for maybe this is for Hillary. But the Attorney General, State's Attorney, Defender General, did they testify in the House on this? And do you recall what they testified to? They did.
I'd have to check.
Okay.
I do not immediately recall if they did on this bill.
Okay. We'll reach out to them anyway, just to check that off and make sure there isn't anything that we're missing or anything that they wanted to chime in on for this. It seems pretty straightforward to me. So, committee, any questions for Judge Dunn? Okay, great. Well, thank you.
Thank you.
Appreciate it. Thank you for the thorough explanation.
That was Hillary.
Yes, yeah, that's what that was a good hint. Okay, so we have plenty of time. We see if Karen and Claire can come in maybe at 9:45. So 193. Thank you.